We can go ahead and go on the record. Good morning. It is April 9th, 2019, and we are resuming with a hearing in EA 2019-0010. And when we left yesterday afternoon, Mr. McMahon was on the stand, and I asked him to return today in case there were any additional commissioner questions. There were not any additional commissioner questions for him, so I apologize for making him stay over if that wasn't necessary, but he is now excused. And we can go ahead and begin with Empire's next witness.
Judge, we would call Timothy Wilson.
And I guess I should say we have a few witness hitches today. I'm informed that Mr. Hyman is ill and so will not be appearing today. We will take him tomorrow and make accommodations for him as necessary. And we may also have some renew witness stuff, but we'll deal with that when we get there. So would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. You can go ahead.
Please state your name.
Timothy N. Wilson.
By whom are you employed and in what capacity?
I'm employed by Liberty Utilities Service Corp. as the Central Region Director of Electric Operations Services.
Have you caused to be prepared for this testimony or for this case certain direct and rebuttal testimony in question and answer form?
Yes.
And does that include both your corrected direct testimony in the EA 2019-0010 case, your direct testimony in the EA 2019-0118 case, and then just your rebuttal in the 0010 case?
Yes.
And is it your understanding that that direct testimony, corrected direct testimony from 0010 has been marked as Exhibit 9 in HC confidential and public versions, that your direct testimony from 0118 has been marked as Exhibit 10 in highly confidential, and public versions, and that your rebuttal testimony has been marked as Exhibit 11 in highly confidential and public versions?
Yes.
Do you have any changes you would like to make to that testimony at this time?
I do not.
If I were to ask you the questions which are contained in Exhibits 9, 10, and 11 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Okay, Your Honor, I would offer Exhibits 9, 10, and 11 in all forms and tender the witness for cross-examination.
All right. Would there be any objection to Exhibits 9, which is highly confidential and public, 10, which is highly confidential, and public, and 11, which is highly confidential and public? And did I say that correct? Is there also a confidential 9?
There is, yes,
Okay.
Judge.
And also 9 in the confidential version. Any objections? Seeing none, I will admit Exhibits 9, 10, and 11 in those formats. Is there cross-examination from Renew Missouri?
No, thank you, Judge.
Division of Energy? MECG?
No questions.
Staff?
No questions.
Public Counsel?
Thank you, Judge. Good morning, Mr. Wilson.
Good morning.
I think you were here when Mr. Mertens was testifying. Do you recall I asked him some questions about the Meridian Way and Elk River purchase power agreement?
Yes.
Were you familiar with when those agreements were entered into by Empire?
I am generally familiar with that. I was in a different role at the time, but I'm generally familiar with at least the the dates at which we entered into them and their expiration dates.
Do you know why Empire entered into the Meridian Way and Elk River agreement?
I'm more familiar with why we entered into the Meridian Way agreement, as I wrote a memo that outlined the responses to and the evaluation that we performed and why we chose Meridian Way at that time.
And why was Meridian Way chosen at that point in time?
At that time, we did not have a capacity need, and it was made based upon economics known at that time.
When you say economics known at that time, were there projections considered in determining the economics of entering into that agreement?
Yes, there were.
It is a 20-year agreement, is it not?
It is a 20-year agreement. It expires in 2028.
And were those projections on the economics accurate?
I think the projections on the economics made at that time were the best projections that were available at that time.
But that's not my question. I'm just asking, did they turn out to be accurate?
If you look at a vacuum, maybe 1 year, no. But I know certainly in the early years, it was very much so a hedge against high natural gas prices.
Have they become, have the projections that were made, say, for 10 years out, turned out to be accurate?
I don't have an analysis in front of me that would say one way or the other, but I know it has been, quote unquote, good in certain years not as good.
Do you know if the revenues from the SPP markets, say, for the year of 2018, have exceeded the cost of the purchase power agreements for Meridian Way?
I don't have that number in front of me.
Are you saying you don't know? I'm not asking for a number. I'm just saying has it exceeded or not?
To be honest, I would expect that the SPP revenues associated with Meridian Way probably do not match up with the costs associated with the purchase power agreement in 2018 for that contract.
And the same for Elk River. Do you have any sense about whether or not the revenues from SPP exceed the cost of the PPA?
Again, I don't have those exact numbers in front of me. That one would be closer to what you would consider a break even than probably Meridian Way for 2018 especially.
And why is that?
It's cheaper.
Substantially?
Depending on what your version of, your meaning of substantially is. I don't recall exactly the dollar per megawatt hour we're paying for both, but it's probably 20% lower.
Yeah, and I don't want to get into anything confidential or highly confidential.
That's what I'm trying to stay out of.
Well, you've given me what I was looking for.
Yep.
Thank you.
Absolutely.
Do you know if anyone else is developing any utility scale wind projects in Missouri within or near Empire's territory?
Yes.
And is anyone else looking at developing wind projects in or about Empire's territory that would be utility scale aside from Empire?
I believe so.
And how big is the project and who's doing in that?
I think in response to OPC 2035.1, we identified applications in the SPP generation interconnect queue that are in our service territory.
In Missouri?
In Missouri.
And what is your response there?
Could you repeat the question?
What is your response? You referred to a data request response. What's the response?
Well, the question was, are any of the units listed above in the SPP generating queue submitted by Empire? And the answer was no.
Are you familiar with Avangrid?
I am.
It's formerly known as Iberdola, correct?
Correct.
And do you know if Iberdola looked at the potential for developing wind farms at or near the sites of Kings Point and North Fork?
Through previous Empire employees, I am aware of the fact that Iberdrola at that time, in the 2011 timeframe, did look at potentially construction of wind farms in and around the areas of North Fork Ridge and Kings Point.
In fact, Empire's acquired some wind data from Avangrid, has it not?
We have.
But Iberdola did not go forward with building those wind farms, did it?
No, it did not.
Thank you. No further questions at this time.
Thank you. Are there, excuse me, are there commission questions for Mr. Wilson? Mr. Chairman?
Yes, thank you. Good morning, Mr. Wilson.
Good morning.
Do you have a copy of the non-unanimous STIP?
Which one?
The one that we're...
Yeah, he's talking, not the wildlife one, but
Okay,
the,
for this
sorry, I
case.
worked on the wildlife one.
Yeah, okay, no, for this case, yes. If you could turn to page number 5, please. Yes. The last sentence of the top paragraph there says, in its subsequent quarterly report, Empire shall address any results of the study that are material changes in assumptions or costs related to the wind projects. I had asked one of the witnesses yesterday what the definition of material was in this sense, and they suggested you would be the witness to clarify that.
Okay. Generally, whenever we do, with any project we've done, we've always worked with commission staff and the parties to provide cost reports. And so we would be generally consistent with what we've done in the past with respect to reporting on this project as well.
So is there a threshold, either percentage of cost or total dollar figure that you think would be material, or?
I agree,
You're
there's no
telling me it's-
definition of material. What I would say is this is with respect to the GIA interconnect queue, the DICES study results. And that will actually go into the market protection provision calculation. So in my opinion, regardless of its material or not, or even lower, we would still provide that information as it is a direct input to the MPP calculation.
Okay, thank you.
Commissioner Kinney, any questions?
No questions.
All right, I just have a couple about the transmission lines.
Okay.
So as part of this application, or these applications, Empire is asking to construct approximately 20 miles of the tie lines.
The GenTie line, correct.
Yes. It was unclear to me, have those landowners or easements been obtained for that already, or?
Yes, so we had two separate kind of land rushes, so to speak. The first was with respect to the footprint where we were going to develop and build the turbines on, which is about 50,000 acres in total of the two sites. The second land rush was to actually get the easements, as you are asking about, for the GenTie lines. And yes, we have obtained all of the easements for all 20 miles.
Okay. Okay, is there further cross-examination based on bench questions from Renew?
No, thank you, Judge.
Division of Energy? No, Your Honor. MECG?
No, Your Honor.
Staff? Public Counsel?
No.
Is there any redirect?
No redirect.
Okay, Mr. Wilson, there could still be another commission question for you, so I'd ask if you're not in need of rushing off, if you could remain for another hour or so until.
Absolutely.
I make sure.
All right.
Okay, thank you.
Thank you.
You can step down for now. Are there any other Empire witnesses? Is that the last?
That's our last witness, yes, Your Honor.
Okay, then we are ready to go to Renew Missouri, and I believe you all had an agreement about his testimony.
Yes, good morning, Judge. I inquired of the parties who are participating, and they all agreed to waive cross on Mr. Owen. If the commissioners are willing to waive cross as well, I would move the admission of Exhibit 300, the surrebuttal testimony of Mr. Owen. And if they do have questions, I can make him available this afternoon.
All right. Any commission questions? I don't believe there's any commission questions, so we can go ahead with admission of his testimony.
Yeah, so I would move for the admission of Exhibit 300, the surrebuttal testimony of Mr. James Owen.
Would there be any objection to exhibit number 300, the surrebuttal testimony of James Owen? Seeing none, then I will admit that.
Thank you, Judge.
Thank you. All right. So that then brings us to Division of Energy, but Mr. Hyman is ill this morning. We hope that he will be available tomorrow, so we're going to skip over him and go to staff.
Judge, to the extent it would help move the process along, Public Counsel has no cross for Mr. Hyman if no other party does and the commission does not.
Okay. Would there be? Does anyone know of any other cross for Mr. Hyman?
There's been several questions about a provision related to Asbury and employment, and Mr. Heineman, in staff's view, would be the most appropriate witness to answer those questions, and I know that that has been
Okay.
something that's come up several times, so I hate to make him do it, but
No, that's fine. We'll keep him on the list until we see how things go tomorrow. So that brings us to staff's witnesses.
staff would call Natal Dietrich to the stand.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
Yes.
Thank you. Go ahead, Ms. Mers.
Will you please state and spell your name for the record?
Natel, Natelle, Dietrich, Dietrich.
And by whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as the Commission Staff Director.
And are you the same Natal Dietrich who contributed to the rebuttal testimony of Natal Dietrich, which has been marked as Exhibit 100, the staff rebuttal report, which has been marked as Exhibit 101 in highly confidential and public form, and the staff appendix, which has been marked as Exhibit 102?
Yes,
Do you have any changes or corrections to your testimony?
I do not.
And is your if I asked you those questions today, would you give a substantially similar response?
Yes,
And are those responses true and accurate to the best of your knowledge and belief?
yes, they are.
At this time, I would offer Exhibit 100.
Would there be any objection to exhibit number 100? Seeing none, I will admit exhibit 100.
And I tender the witness for cross.
Is there cross-examination from MECG?
No, Your Honor.
Division of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
No questions.
Public Counsel?
Thank you. Ms. Dietrich, do you have a copy of the second stipulation and agreement, the one that's more global in nature?
I do.
Turning to page 4 on number 12, subpart A. Would you take a look at that provision?
Okay.
And what is staff's understanding of the language at the end of that sentence, or clause, I guess, and in a manner that is not detrimental to EDE's customers?
Well, to start, I would say you have to read the entire sentence together where it says, "The wind project shall be operated in accordance with applicable SPP integrated marketplace rules and in a manner that is not detrimental to EDE's customers." So the way I read that provision is that the projects will be operated according to SPP rules, and as such, they would not be detrimental to EDE's customers, and then just that Empire would not do anything to harm EDE's its customers through the operation of the wind projects.
Not trying to put words in your mouth, but are you saying that the operation would be within the scope of the Southwest Power Pool Integrated Marketplace rules, and then within those rules, it has to be in a manner that's not detrimental to Empire's customers?
And then also just in general, the operation would not be detrimental to Empire's customers.
Okay. And Chairman Sylvie was asking Mr. Wilson about material changes in assumptions or costs, which is on page 5 in 12D, toward the end of that. In fact, it's the last clause in that provision. What does staff consider to be material changes in assumptions or costs?
This particular section is talking about plans and specifications, and specifically construction level plans and specifications. So in staff's opinion, if there were material changes to what was filed in the application, what the commission has considered as part of granting the CCN, they would be subject to analysis perhaps in the future. In other words, in these quarterly reports, Empire would be reporting any changes. Any party would have the opportunity to review what Empire is reporting and ask them to explain it, or potentially bring something before the commission if they felt it was in conflict with or substantially different than what the commission approved.
Is materiality here like beauty? It's in the eye of the beholder, or are there some more specific criteria staff has in mind?
I would say there's no specific threshold. To use your words, it would be in the eye of the beholder. For instance, if for some reason a location of a wind farm had to be changed, and it wasn't something that was considered in the various FAA documents or analyses and things like that, that might be something. If the turbine had to be taller for some reason, just some things like that, that it would just have to be on a case-by-case basis.
And then in the next subsection E, there's also a reference to materiality, material changes in assumptions or costs related to the wind projects. Who determines whether or not a change in assumption or cost is material?
Well, in this particular provision, it says Empire shall address any results that are material in its assumptions. So initially Empire would, but I would say the same thing, that it would be subject to the other parties being able to address it also, or raise concerns with Empire, asking them questions, and potentially filing something with the commission if they, meaning the parties, determined that it was something that should be brought to the commission's attention.
Does staff consider paragraph 13 to have rate-making implications?
I'm not sure what you specifically mean by rate-making implications, but it does say subject to audit in ED's next general rate case, so it would be something that the commission staff and any other party could audit.
Well, does being authorized to record its capital investment to acquire the wind projects as utility plant and service, in staff's view, have rate-making implications?
The commission could look at the prudency of those costs or account, the information in that account, but I think it does imply some level of comfort for the company that it could recover that information or that amount. And I would say Mr. Oligschlager may be a better person to ask the specifics on plant and service accounting.
With regard to the market price protection mechanism, which is referred to on, I guess it's paragraph 21 on page 9. The mechanism that's referred there can be, it'll be at least 10 years in length, will it not?
10 years from the date of the last project going into rates is my understanding.
So it could be longer than 10 years potentially.
Correct.
And then on page 10, this is in regard to paragraph 22 that talks about future battery energy storage technology. There's a reference about making a presentation to the parties. What's your understanding of who the parties are in that reference? Or staff's understanding?
Most of the references in the stipulation refer to signatories. Since this provision refers to parties, I would view that as any party to the case, not just those that were signatories to the stipulation. So, for instance, OPC and the couple that did not sign on to the stipulation but indicated that they had no objection.
So you believe parties means the parties to this case?
Yes.
No further questions at this time. Thank you.
Okay. Thank you. Are there commission questions? Not seeing any. Is there any redirect?
Briefly. You were asked about the material change and assumption that is in various places, or well, two sections. If you turn to page 2 of the stipulation and look at provision 5.
Okay.
Do you understand that provision to also allow parties to have the ability to bring issues in front of the commission if there is differences between what was represented in this case by Empire and what the final reports would show?
I think paragraph 4 and 5 have that connotation. Paragraph 4 says the stipulation is based on the circumstances EDE presented, and then at the end of that it says it shall not have precedential impact on any other commission proceeding, and then 5 also says that the stipulation is based on the information provided by Empire.
Okay. And you were also asked about provision 13 on page 7 about rate basing the wind projects. And I know you're not an accountant, but to your knowledge, would this treatment be any different from any other CCM case?
No.
All right. I have no further questions. Thank you.
Thank you. I believe that concludes your testimony, and you may step down, Ms. Dietrich. Staff like to go ahead and call its next witness. Staff calls Jay Lubert to the stand. Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
Yes, I do.
Thank you.
Will you
Go ahead.
will you please state and spell your name for the record?
Letter J, Lubert, Luebbert.
And by whom are you employed and in what capacity?
I work for the Missouri Public Service Commission as a case manager.
And are you the same Jay Lubert who contributed to staff's rebuttal report, which has been marked as Exhibit 101 and highly confidential in public form?
Yes, I am.
And the appendix, which has been marked as Exhibit 102?
Yes.
Do you have any changes or corrections to your testimony?
No, I don't.
And is that testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
And if I asked you those same questions today, would you give the same responses?
Yes.
All right. I will tender this witness for cross then.
Is there any cross-examination by MECG?
Very briefly, good morning, sir.
Good morning.
You're familiar with the market protection provision, is that correct?
I am.
And the market protection provision in the non-unanimous stipulation differs from the MPP that you recommended in the staff report, is that correct?
Yes, it does.
Do you find that the market protection provision in the stipulation is in the public interest, and why?
I do. I believe that the agreement that we made for the market protection provision provides a similar sharing of risk on the downside, with the potential for benefits to customers to go, basically all of the upside potential goes to customers, and it also allows EDE the opportunity to potentially get a return on their investment of those wind farms.
No further questions, thank you.
Is there cross-examination by Division of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
No questions.
Public Counsel?
Thank you. Good morning, Mr. Lubert.
Good morning.
Did staff perform any independent analysis of the economics of Empire's wind projects?
Staff reviewed the evidence that Empire provided both in this case and in the EO-2018-0010 case. There was some additional analysis of the information that they provided, but I don't think that staff did any modeling of its own.
And it didn't rely on any sources other than those which Empire provided, correct? For data?
I think that's correct.
Thank you. No further questions.
All right. Are there commission questions for Mr. Lubert? Mr. Chairman? No questions. All right. Is there any redirect?
Briefly, Counsel for MECG asked you about public interest. Are you aware of any other process or regulation that would support that finding?
Yes. The primary policy objective of Chapter 22 is the reduction of net present value of the revenue requirement. And within this case and the modeling analysis that was provided in the last case, Empire has substantially demonstrated that the addition of these wind projects would reduce the net present value of revenue requirement over a 20-year and a 30-year period. I think the language in the Chapter 22 rule Chapter 4 CSR 240.22.010, the first paragraph says the commission's policy goal. It goes on to say that the planning objectives are to ensure that the public interest is adequately served. The second paragraph then goes on to state that the fundamental objective, among other things, is to provide the public with energy services that are safe, reliable, and efficient at just and reasonable rates in a manner that serves the public interest. And then paragraph 2B of that same paragraph says use of minimization of the present worth of long-run utility costs as a primary selection criteria in choosing the preferred resource plan subject to the constraints thereon. And so, as I said, I think Empire has done modeling analysis that demonstrates that their attempt to comply with that rule.
And Counsel for OPC asked you about relying on information provided by the utility. Is that different from any other case that we participate in?
No, it's not.
All right, no further questions. Thank you.
Thank you, Mr. Lubert. That concludes your testimony, and you may step down.
Thank you.
Staff may call its next witness.
Staff calls Mark Oligschlager to the stand.
So I thought I'd point that out to you in case it comes up.
Okay.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Will you please state and spell your name for the record?
Yes, Mark L. Oligschlager, M-A-R-K, middle initial L, O-L-I-G-S-C-H-L-A-E-G-E-R.
And by whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as the manager of the auditing department.
And are you the same Mark Oligschlager who contributed to staff's rebuttal report, which has been marked as Exhibit 101 in highly confidential and public form, and the appendix, which has been marked as Exhibit 102?
Yes.
And do you have any changes or corrections to that report?
No.
And are your answers in that report true and correct to the best of your knowledge and belief?
Yes.
And if I asked you those same questions today, would you give some similar responses?
Yes.
All right, I would tender the witness for cross.
Is there cross-examination by MECG?
No question.
Division of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
No questions.
Public Counsel?
Thank you. Ms. Dietrich said you're the person to answer this, so
I'll try.
on the non-unanimous stipulation agreement that was filed Friday, paragraph 13 on page 7, does staff view that to have rate-making implications?
Strictly speaking, no. It may be in a broad sense have rate-making implications because booking these costs to plant and service is the normal procedure for making them eligible for recovery in a future rate case.
So something like an accounting authority order impact?
Well, actually, yes, this specifies accounting treatment for the planned investment at issue here.
Are you familiar with that there are excused events in some of the purchase and sale agreements?
Can you define excused events?
Well, my understanding of the excused events are that if certain events transpire, the added cost is something that Empire would bear.
Yes, I believe so.
And under this non-unanimous stipulation and agreement, who would bear the costs of those ultimately if they were to occur? For example, if an excused event occurs so that Empire's costs go up, ultimately, who would bear that increased cost?
Under the terms of the stipulation and agreement, I don't believe it really specifies, so I think the answer to that question would be Empire could conceivably seek recovery of such costs in future rate proceedings, and other parties could oppose.
So it might be a prudency issue that would be litigated potentially.
Yes.
Thank you. No further questions at this time.
Are there questions for Mr. Olschlager from the commission? Mr. Chairman?
Thank you. Good morning.
Good morning.
Do you think that the market protection mechanism in this non-unanimous STIP is more reasonable and offers better conditions than what staff recommended in its original position statement? And if so, why?
In some respects, I think it is superior. For example, I don't think staff explicitly recommended elimination of the deadband in its initial position. I may be wrong about that. But in general, I think it certainly was something we found reasonable, and I think what was in our original position perhaps was more of an ideal situation from ours, and in the give and take of the negotiating process, we did end up with something reasonable.
Okay, thank you.
Any other commission questions? Commissioner Hall?
I'm not sure you answered that question. Because I had that exact same question. I mean, do you think it protects ratepayers as well, or better, or not as well as staff's original position on that provision?
I would say probably our original position can be thought of as marginally more protective of customer interests, primarily because there was no cap on the sharing. It would be 50-50 for all of it, and there is in this negotiated stipulation, there is a cap which limits for the first 10 years the exposure of shareholders, though that is a soft cap, not hard.
Okay. But in your view, it is still a reasonable compromise and balances the interests appropriately?
Yes, I do.
Okay. Are you familiar with paragraph 17 of the non-unanimous STIP regarding Asbury?
Yes.
Do you have that provision in front of you?
Yes, I do.
Okay. Can you explain to me, first of all, what the overall purpose of that provision is?
Okay. And to clarify, the Section A of paragraph 17, I really am not that familiar with that, but to go to sections B and C, what these provisions do is it calls for the creation of certain regulatory assets and liabilities if the Asbury plant is sold or retired between general rate cases. And it does not specify any rate-making treatment regarding Asbury and its retirement status, but instead kind of tees up potential issues for litigation or resolution in future rate cases.
So is the purpose of it to delineate all of the costs and all of the revenues that are related to that facility and allowing the commission at the next rate case to determine what to do with them?
Yes, I would agree with that.
Were you involved in the actual drafting of this provision?
Not directly, no.
Okay, so then to the extent you can answer, the difference in the language between B and C, where B, the commission should authorize a regulatory asset, and C, Empire will create a regulatory liability. Is there a reason for that drafting?
Yes, I would strongly suspect it has to do with this. A regulatory asset means a company believes that dollars will flow to it in the future from customers, okay? But nonetheless, that's dependent on rate-making actions ultimately of the commission, and until the rate case is taking place, you can't be totally certain that any such flow of dollars from customers to the company will take place. So there have been issues in the past where, particularly I think the external auditors of a utility may question a company's booking of a regulatory asset because there's not sufficient evidence to support a finding that there will be a likelihood that such costs will flow in the future. And I think this language is generally intended to provide greater comfort to the company in regard to that.
Okay, we if and when the facility is sold or retired, it will be known what the undepreciated balance is, correct?
It should be, yes.
So why is there any question about that?
Actually, that goes back to, I think, an issue in the 2018-0010 case where I think the company at that time asserted that to avoid writing off the undepreciated value at the time of retirement, they would need this kind of accounting support. At that time, the staff, I believed, was not sure that that was strictly required under normal retirement accounting. So I would say that this provision is here in order to give the company comfort that kind of in the worst case scenario, they will not have to immediately write off that undepreciated balance.
And is it your understanding that with regards to provision C, that the regulatory liability would include the return on equity related to that facility?
I would interpret it as including return on equity because there is a reference to capital costs being deferred.
Do you believe that it is appropriate in a certificate case such as this to be making decisions such as those set forth in paragraph 17?
I would say in most CCN cases, these issues should not arise, or this type of issue should not arise. This is, in some respects, a fairly unusual application, and that's why that's here. I'm not sure that answered your question, but...
So it's unusual, but it's not necessarily inappropriate. Would that?
I would, yes.
Okay. I have no further questions. Thank you.
Is there any further cross-examination based on questions from the bench from MECG?
Very briefly, you were asked a question on provision 17B, and you talked about, I think the word was likelihood of recovery. Do you recall that?
Yes.
And likelihood does not imply a guarantee of recovery. Is that correct?
No, it's more like probable of recovery.
Okay, and it's something just to provide some level of comfort regarding the booking for the external auditors. Is that your understanding?
Yes.
Okay, no further questions. Thank you.
Anything from Division of Energy? Renew Missouri?
No, thank you.
Empire?
No, thank you.
Public Counsel?
Thank you. You recall the chairman and Commissioner Hall asking you some questions regarding staff's original position and then the position in the non-unanimous stipulation agreement?
Yes.
And you testified that you viewed the non-unanimous stipulation and agreement to be an appropriate balancing of the interests of the parties in the case?
Yes.
Was staff's original position an appropriate balancing of the positions of the parties in the case?
I certainly would characterize it that way, yes.
But the two are different, are they not?
Well, I don't know that there's one right answer in these types of situations.
Have you ever seen any other certificate case before the commission where the commission addressed future rate making in that case?
I don't recall any. I'm not sure that the commission is being asked to address future rate making directly within the stipulation.
Well, are you familiar with any other case where the commission's engaged in the kind of, let's call it, direction toward rate making in a certificate case that's being proposed in this one?
No directly analogous case comes to mind.
Thank you. No further questions.
Is there any redirect by staff?
You were asked by counsel for OPC about excused events. In your view, would excused events that increase the wind project cost, not only would those be subject to a prudency review, but would they be covered by the market protection provision?
They would be subject to a prudency review, and if they pass that test, then those costs would flow into the market protection provision.
And your understanding of the market protection provision is just what the wind project costs are?
Costs and revenues, yes.
You were asked by the commissioners, the differences between our position and the stipulation. Is it your understanding that the stipulation cap was developed to cover the worst case?
Yes, kind of the ballpark what the worst case would likely be, and actually I believe from our perspective, perhaps the cap is even excess of that.
And what happens to costs that in the highly, highly unlikely event that the cap was breached? What happens to those costs at the end of 10 years?
You mean that the $52.5 million cap is reached, but the total financial loss associated with the project exceeds actually $105 million. In that case, any excess, it is my understanding, could be addressed in the next general rate case, and parties could make arguments about further sharing, perhaps 100% assignment to customers, perhaps 100% assignment to shareholders for those costs.
And you also had some commission questions about Asbury. In your view, does those provisions, do they have the benefit of addressing all the pieces of the Asbury pie at one time?
I think it's fairly comprehensive in terms of Asbury costs and specifying future accounting treatment.
I have no further questions. Thank you.
Thank you. That concludes your testimony, Mr. Oelschlager, and you may step down. Staff may call its next witness.
Staff calls Jeffrey Smith to the stand.
Swear you in? Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Will you please state and spell your name for the record?
My name is Jeffrey Smith, spelled Jeffrey Smith.
And by whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission. I work as a utility regulatory auditor in the Financial Analysis Department.
And are you the same Jeffrey Smith who contributed to staff's rebuttal report, which has been marked as Exhibit 101 and highly confidential in public forms, and Exhibit 102, the appendix?
Yes,
And do you have any changes or corrections to that testimony?
I do not.
And is that testimony true and accurate to the best of your knowledge and belief?
Yes,
And if I asked you those same questions today, would you give the same answers?
I would.
I would tender the witness for cross.
Is there cross-examination by Missouri Energy Consumer Group,
No questions.
Division of Energy? Renew Missouri,
No, thank you, Judge.
Empire,
No question.
Public Counsel?
No, thank you.
Are there questions from the commissioners? Mr. Chairman? Mr. Giddey? Let me check really quick. Okay, I don't believe there are any questions. In that case, you may step down.
All right.
Boy, you get the air conditioning fixed and things just move right along. Staff can call its next witness.
Staff would call Cedric Cunnigan to the stand.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Will you please state and spell your name for the record?
Cedric, Cedric, Cunnigan, Cunigian.
By whom are you employed and in what capacity?
The Missouri Public Service Commission, and I'm a Utility Engineering Specialist 3.
And are you the same Cedric Cunnigan who contributed to staff's rebuttal report that's been marked as Exhibit 101 HC and P and Exhibit 102 staff appendix?
Yes.
And do you have any changes or corrections to that rebuttal report?
No.
Is your contribution to the rebuttal report true and correct to the best of your knowledge and belief?
Yes.
And if I asked you about those same topics today, would you give substantially similar responses?
Yes.
I tender the witness for cross.
Is there cross-examination by MECG? Division of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
No questions.
Public Counsel?
No, thank you.
Are there any commission questions? I'm not seeing any questions for you either. So you may step down. Staff can call its next witness.
Staff calls David Buddig.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Will you please state and spell your last name for the record?
My name is David Buddig. Last name is Buttig.
By whom are you employed and in what capacity?
I work for the Missouri Public Service Commission as utility regulatory engineer.
And are you the same David Buddig who contributed to staff's rebuttal report marked as Exhibit 101, highly confidential and public, and Exhibit 102, staff appendix?
I am.
Do you have any changes or corrections to the rebuttal report?
I do not.
And is your contribution to the report true and correct to the best of your knowledge and belief?
It is.
If I asked you about those same topics today, would you give substantially similar responses?
I would.
I tender the witness for cross.
Let me just ask if there's going to be any cross-examination for this witness. I'm not seeing any. Are there commission questions for this witness?
No.
All right, then I guess you may be excused.
Staff calls Sean Lange to the stand.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Will you please state and spell your name for the record?
My name is Sean, Shawn, Lange, Lange.
And by whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission as a Utility Regulatory Engineer 1.
Are you the same Sean Lange who contributed to the staff rebuttal report marked as Exhibit 101, highly confidential and public, and Exhibit 102, staff appendix?
I am.
Do you have any changes or corrections to the rebuttal report?
I do not.
And is your contribution to the rebuttal report true and correct to the best of your knowledge and belief?
Yes.
If I asked you about the same topics today, would you give substantially similar responses?
Yes.
I tender the witness for cross.
Are there cross-examination questions for Mr. Lange? Is there any commission questions? Okay, just one second. Don't believe there are any questions for you either, Mr. Lange. You may be excused. Oh, I'm sorry, Commissioner Hall?
Can you tell me what additional transmission would be required related to the Kansas facility? I'm blanking on the name of that one.
Neosho Ridge?
Yeah.
When you're asking additional transmission, currently the study is not complete, so as to what it would cost to interconnect or upgrades or any of that, it is not kind of set in stone, if you will.
You would anticipate that there'd be some additional transmission needed, or would it just be a line to an existing? Do you assume that there will be some additional transmission needed?
I assume that there will be additional costs associated with network upgrades.
Okay. Do you believe that any of those network upgrades could have benefits along the MISO SPP seam in general?
They could.
Could you elaborate on that?
The Neosho to Riverton area has tended to have a lot of congestion issues. Over the last year or so, they have gotten better. But as of right now, the seam there tends to be, it tends to have implications in the MISO market as well as the SPP market, and there is some payments from MISO to SPP and SPP to MISO because of congestion in that area.
And are those payments made by all of the utilities in each of those two RTOs, or is it just the ones along the seam?
I believe it is market-wide.
Is SPP looking at any additional upgrades separate and apart from this project on that Neosho Riverton line?
I just want to interrupt just in case, just noting that a lot of Mr. Lengy's testimony is marked as highly confidential, so don't answer anything that was supposed to remain confidential, but
Thank you.
thank you.
I'm sorry, would you mind repeating that?
As far as you know, is SPP looking at doing some additional upgrades on that Neosho Riverton line separate and apart from this project?
I know that there have been projects that have been proposed. I do not know where they may be as far as in the queue or not in the queue or been voted on. I am not aware of that.
And there was some discussion of this yesterday, but do you have an understanding as to the timeline for those interconnection studies?
My understanding would be consistent with the company. And in fact, they responded to a data request by staff that in that response, they say the study is expected now to begin in June of 2019 with the results of the first round of modeling to be delivered in October of 2019.
Okay. Can you tell me why this testimony regarding transmission interconnection is confidential? And if you want to look to your lawyer for that, that's obviously fine. However.
That information was marked confidential by the company.
Okay, hot potato gets passed.
I apologize, I'm getting back to Mr. Lange's portion here. So I think in fundamental part, it includes the estimates of those transmission costs that the company has. Those are important to its overall project costs. It's ultimately important to the prices of the projects and what they may be reflected into the SPP market. It's all a part of that bigger picture, is why the company has marked it highly confidential, and the various sort of concerns and possibilities and those sort of things all have some impact for the ultimate cost of that transmission interconnection. So I believe that's the company's reasoning.
Okay, thank you.
I just have one question for you, too. And on page 33 of the staff report, and again on page 34, the non-confidential parts of your testimony says that the interconnection cost issues staff is raising will be alleviated with the proper inclusion of network interconnection costs in the updated MPP as proposed by staff. And then later, it again says all of these concerns would be alleviated if properly taken into account in the updated MPP as proposed by staff. and again, subject to staff's proposed conditions. So my question for you is, are those concerns all still alleviated under the MPP in the proposed non-unanimous stipulation and agreement, as well as that proposed by staff?
Yes.
Okay. Right. Is there cross-examination based on questions from the bench, from MECG? Division of Energy? Renew Missouri?
Thank you, Judge.
Empire?
No questions.
Public Counsel?
Yes, thank you. You recall Commissioner Hall asking you about generation interconnection agreement study timelines?
Yes.
And then if I recall correctly, you said that, well, your response was based on information you obtained from Empire, correct?
Correct.
And if I recall correctly, you said that there would be a first round result anticipated in October of 2019, is that correct?
Yes.
That implies that there will be subsequent rounds. Would you expect that the study to be, and I'll use the word final, the final costs and what will actually definitively be accomplished before a generation interconnection agreement is signed, to be completed by October of 2019, or do you anticipate there'll be more studies or more work on a study?
I would suspect there would be more work, potentially.
And do you have any time frame for how long that will take?
I do not.
No further questions, thank you.
Thank you. Is there redirect? All right, then, I believe that concludes your testimony, Mr. Lange, and you may step down. Staff may call its next witness.
Staff calls Claire Eubanks.
Sorry. Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Would you please state and spell your name for the record?
Claire Eubanks, CLAIRE-EUBANKS.
By whom are you employed and in what capacity?
I am employed with the Missouri Public Service Commission as a utility regulatory engineer 2.
Are you the same Claire Eubanks who contributed to staff's rebuttal report marked as Exhibit 101, highly confidential and public, and Exhibit 102, the staff appendix to that report?
I am.
And do you have any changes or corrections to the rebuttal report?
I do.
Could you please point those out to me?
I have a revised Figure 1.
So is that found on page 17 of the staff report?
It is, thank you.
And with that change in mind, is your contribution to the rebuttal report true and correct to the best of your belief and knowledge?
It is.
And if I asked you about those same topics today, would you give substantially similar responses?
I would.
Staff circulated this updated figure to the parties last week, and with that change, we would like to offer Exhibit 101HC, 101P, and 102.
Okay, so the correction is the updated chart, Figure 1, on page 17 of the staff report, correct?
That's correct.
Okay. And with that correction, is there any objection to Exhibit, this is the last witness, so you offered this, is that correct?
Yes.
Sorry, I was getting ahead of myself. Is there any objection to the staff rebuttal report with that correction being entered as Exhibit 101? And that is both a highly confidential and a public version.
No, and public counsel doesn't oppose the staff appendix either.
Okay, thank you. I'll just ask for objections then to Exhibit 102 at the same time. Seeing no objection, I will enter those into the record.
I tender the witness for cross.
Is there any cross-examination by MECG?
Very briefly, Your Honor. Good morning.
Good morning.
Rather than spend a bunch of time looking at this, can you tell me what is the nature of the change between the original Figure 1 and the corrected version?
Sure. So there were two changes. One, simply the non-solar rec production was cut off in about the 2028 timeline. As we all know, there's two existing wind farms that produce renewable energy credits for Empire. There's also a hydro facility, so that just shows that continuing on. And then the other change was the green shading, the non-solar rec production, was the Missouri jurisdictional allocation of recs in the original figure, and is still on this figure. But for the new wind farms, I went ahead and made the change so that it's showing just the Missouri allocation of recs for the three new wind farms.
No further questions.
Any cross-examination by Division of Energy?
No, Your Honor.
Renew Missouri?
No, thank you, Judge.
Empire?
No.
Public counsel?
Thank you. Are you familiar with the renewable energy credit production associated with Meridian Way and Elk River purchase power agreements?
Generally, yes.
Are they more than sufficient to meet for non-solar renewable energy credits, the Missouri renewable energy standard?
They are. For currently.
And is there any reason that you know of why they would not be able to satisfy those requirements at least until 2027?
There is no reason that I am aware of, no.
And cannot a utility bank credits for 3 years?
They can. In the 2027 date, I was assuming kind of baked in that. So my understanding is one will retire in 2025 and one will retire in 2028.
And will the one that will retire in 2028 not generate enough credits that Empire should be in a long position on renewable energy credits till 2030?
I didn't specifically look at the banking of RECs when I put this together, so I would imagine there is some level, but I don't know exactly.
So your answer is, I don't know.
I don't know.
But it's a possibility.
It is.
Then turning to your Schedule CMER1, which I believe is the same as Appendix A to the non-unanimous stipulation and agreement, is it not?
It is.
Would you turn to, I don't care if you want to look at your schedule or if you want to look at the appendix to the stipulation and agreement.
I have the schedule in front of me.
Well, if you turn to page 1 of 2, first of all, there are 2 number 5s on there, are there not?
Yes, there are.
And there are references in the first paragraph 5 to Part 4. What is Part 4 referring to where it appears in paragraph 5?
Let's see.
And it shows up there at least 3 instances, so.
Excuse me while I interrupt again. So this schedule is again marked highly confidential, but I don't see any particular text in it marked highly confidential.
No, Your Honor, I think that the designation, if you're looking at the header, that's the header that continues all through the highly confidential.
Well, I'm actually looking at the note at the bottom by the page number.
Oh.
But
I'm looking on the stipulation version, so I
okay,
apologize.
I'm sorry. I'm looking at the schedule attached to the testimony. I guess my question is just, is there any confidential information in this schedule? Pages 1 and 2 is attached to staff report.
Company, it's a public,
It's public now, it's not.
it's public in the stipulation. That was the intent in the stipulation. I think there were other reasons probably at the time.
Okay. So-
It was identified as HC in that staff report.
Okay, I just want to clarify then that schedule attached to staff report is not highly confidential. So, I'm sorry, go ahead.
Okay, so I believe your question was related to the numbering of the items in Part 5, which references Part 4. Those should be Part 5.
So where it says in that first paragraph 5, numbered 5, the references to Part 4 should be references to Part 5?
That's
Those
correct.
3 occasions.
Yes.
So, and they're referring to that same paragraph or a different paragraph?
In 5A, it's-
Well, this Part 4, is Part 4, you've now said should be Part 5. Is that, those all references to paragraph 5?
yes.
And we're talking about the first paragraph 5, so, correct?
Yes, the first paragraph 5, which should remain 5. Anywhere it says Part 4, it should actually say Part 5.
Right, and Part 5 is referring to that same paragraph, though. When you have the reference to Part 5, it's referring to that same paragraph,
Yes,
correct?
it says outlined in this Part 4, but it should say in this Part 5. Do you,
I'm just after clarification, that's it.
yes. And then the second number 5 should be number 6. And, yeah, there should be changes to this for numbering purposes.
I just was trying to get clarification. I think I've obtained that, so I have no further questions. Thank you.
Are there commission questions? Mr. Chairman?
Yes.
Chairman, or Commissioner Hall?
Good morning.
Good morning.
On page 16 of the rebuttal report, and that is a portion that you were responsible for, correct?
That's correct.
On line 3 to 4, Empire anticipates the accredited capacity will range from 15 to 25% of nameplate rating. Is that correct?
That's correct.
Okay, I'm trying to reconcile that with some numbers that are later in the report that are identified as HC, so I will not provide the number, but we may need to go in camera to do so, I don't know. On page 18, and maybe there is a difference in terminology which explains the different percentage, but there's a different number on line 4 than the 15 to 25% on page 16. So can you help me reconcile those numbers?
Yes, so on page 18, line 4 is referring to net capacity factor. And on page 16,
Accredited capacity.
yeah, line
Okay.
4 is accredited
Can
capacity.
you explain the difference between those two?
Sure, so I think I included the definition for, yeah, so I included the net capacity factor definition, that it's representing the P50 median production. And then, that doesn't really explain, sorry, So the accredited capacity is what SPP will provide Empire accreditation for as far as resource planning. So it's a little bit lower, or quite lower than the actual capacity factor of the wind farms.
And what justifies that lower number?
So they have a statistical analysis that is done. And it's laid out in the SPP tariff on how that is calculated. It's something that Empire calculates, I believe, every 3 years based on actual production of the wind farms.
So is it a difference between what can be produced and then what is expected to be produced in terms of the technology plus the anticipated amount of wind equals a maximum amount that you could expect, but then it may only be called upon some portion of that?
Yeah, it's what they're accredited for resource adequacy. So what can be relied upon by SPP.
Turning to page 21, lines 11 through 13, you are saying that the only way that staff can contend that there is a need for these projects is if the MPP is included.
That's correct.
Could you explain that?
Sure. So Empire's justification for the projects was primarily based on economics. So typically, when we're looking at CCN applications in the context of need, there's usually some other benefit that's the primary reason rather than economics being the primary reason. So I think Mr. Olschlager commented earlier that this was a bit of an unusual CCN application. That might not have been his exact words, but I would agree with that.
So only with the protections that are contained in the MPP can staff take the position that the benefits outweigh the costs?
Yeah, for all three wind projects.
And you're looking at the benefits to ratepayers? In that calculation?
Well, I would just comment, it's not a calculation necessarily, it's more of a reviewing of the company's application.
Well, it's a calculation in terms of taking the protections that are provided in the MPP and seeing if that insulates customers sufficiently so that they are getting more benefits than the costs related to these projects.
It's just not a numerical calculation, it's more of a weighing of the information.
So it's more an art than a science?
Correct.
Could you explain to me, and I'm not going to articulate the actual numbers because they're identified as confidential, but the levelized cost of energy numbers that are set forth in Mr. Mooney's testimony that you refer to here, I can't tell if you believe them or not.
That's fair. So the first number on line 2, I won't read the number, but that came from the customer savings plan. And as I understood the company's testimony, they were asserting that that number came from the CSP, and they just needed to show that these 3 wind projects on a portfolio basis had a lower LCOE than that number. I could not find that number in the affidavit of support of James McMahon in that case, though he did touch on the topic of levelized cost of energy. And the work papers staff had were based on, well, I think that goes on to talk about it in lines 2 and 3. I won't read that out. So on one side, tying it back to the CSP was difficult. And then on the other hand, and what was presented in this case, showing that it was lower, the annual energy production estimates would change the LCOE, and staff is simply saying, don't rely on this test of showing a lower LCOE in the determination of need.
What are the other specific conditions that staff is recommending that, other than the MPP, that is relevant to the staff's decision to recommend the commission find that the projects are needed?
I can't think of another one that directly relates to need.
Thank you.
You're welcome.
Any other commission questions? I just have a couple. So, not to belabor the point, but back on the schedule and where public counsel was asking you about the part 4 and the part 5, also in number 2 on that, it mentions the criteria in part 2, 3, 4, 5, and 6. I just wanted to clarify what the numbers should be in that.
There should also be a 7.
So that should basically include all the criteria in all the parts
Yes.
of this.
Yeah.
So, okay. So both 5s and 7.
Yes.
Okay. Thank you for that clarification.
You're welcome.
Then in the staff report, in the testimony, and Commissioner Hall kind of touched on this, but you state at page 21, line 12, and you say, as discussed in this report along with the MPP, only then can staff state the wind projects would provide benefits justifying their costs and thus satisfy the need criteria under Tartan. Are you saying that the proposed stipulation and agreement meets all of those qualifications? And
Yeah, my understanding is the proposed MPP and then second non-unanimous stipulation and agreement is very similar in as far as protections go.
Okay.
Yes.
And on page 35, similarly, you say at line 12, staff's assessment concludes that the 3 wind projects with staff's recommended conditions are not detrimental to the public interest. If the commission were to adopt the provisions of the stipulation and agreement, do you still believe that it's not detrimental to the public interest?
I do.
And then on the next page, page 36, you You recommend that various definitions be included for the in-service criteria. Were those included?
In the schedule, yes, and my schedule was what was used in the non-union stipulation agreement.
Okay, I thought that was the case, but then I had myself confused, so. Okay, that's all the questions I have. Is there further cross-examination based on questions from the bench from MECG?
Judge, before we go forward with that, could we take a 10-minute break for the company to have a short discussion here?
Sure. We're about due for a break anyway. So let's go off the record and return in 15 minutes. Come back at 25 after.
Okay, thank you.
Go ahead then and go back on the record. And we're back after our intermission. Mr. Cooper, did you all get taken care of what you needed to get taken care of?
We did. Thank you, Your Honor.
And so we can resume with further cross-examination of Ms. Eubanks. All right. I think I asked this, but is there any further cross-examination from MECG?
No question.
Anything from Division of Energy?
No, Judge.
From Renew Missouri?
No, thank you, Judge.
Empire?
Yes, Your Honor, just briefly. And I think maybe this is something that you answered from the law judge as well, but on page 21 of the staff report in your section there where we talk about essentially you're okay with things as long as the staff's MPP is adopted. You see that testimony?
I do.
And now, this of course was written before the stipulation, the non-unanimous stipulation was filed, correct?
It was.
And at this point in time, now that you have the benefit of the non-unanimous stipulation, would your statement be true as well for as long as the commission adopted the non-unanimous stipulation version of the MPP?
It would.
Okay, thank you. That's all questions I have.
Anything from public counsel?
Yes, because of a question you asked. I'm looking at the Appendix A to the non-unanimous stipulation agreement, and paragraph 2 is written, has a circular reference to part 2.
I don't have a copy of it. I'm sorry.
Well, it's the same as that schedule in your testimony. You testified to that earlier?
Yes.
Paragraph 2 has a circular reference to part 2, I believe. And I don't see a reference to paragraph 1. So I'm wondering if either paragraph 1 and 2 should be relabeled, or if the reference in paragraph 2 should be to paragraph 1. Or maybe it's written as intended, I don't know.
It would probably make more sense if there was no reference to part 2. Yeah.
Well, as all major construction work shall be completed and in-service criteria.
It is an in-service criteria, yes. I think it contemplates possibly the wind turbines coming in at separate times, and that might be the reason for the...
Well, paragraph, okay. No further questions, thank you.
You're welcome.
Thank you. Is there any redirect from staff?
Just a few questions.
Sure.
Are resource adequacy requirements calculated based on load serving entities' peak load?
That's correct.
And is the capacity factor used to estimate overall energy production of a wind farm?
That's correct.
And one last question, does the MPP primarily focus on risks associated with the projects as opposed to customer benefits, which were modeled in the previous case?
I think what you're asking is, does the MPP mitigate risks associated with the projects?
Yes.
I agree.
Okay, thank you. No further questions.
Okay, I believe that concludes your testimony, Ms. Eubanks, and you may step down.
Thank you.
Okay, now, I think that was the end of staff's witnesses. Is that correct? Did I miss anybody? And next on our original schedule was Department of Conservation, but they have already been excused. So that brings us to Public Counsel.
Public counsel calls Dr. Jeff Mark.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. You can go ahead, Mr. Williams.
Would you please state your name and who you're employed by?
It's Jeff Mark. I'm employed by the Office of Public Counsel.
Mr. Mark, did you prepare rebuttal testimony and surrebuttal testimony that have been marked for purposes of this evidentiary hearing, exhibit numbers 200 and 201?
Yes.
And do both contain highly confidential information?
They both do, yes.
For those exhibits to be your testimony here today, would you have any changes to them?
I do have one change.
And what changes that and to which exhibit?
It's a rebuttal testimony of Jeff Mark, and it would be, I guess, the first two exhibits that you had listed off. The change is not confidential, but it would be a change to both.
What is the change?
On page 14, figure 1, I've got an update to that. It's as follows. There's a pie chart that's listed. The update, this is listed as of January 1st, 2019. The update would be for February 5th, 2019. Under wind, it's listed, the new number should list as 54,625 megawatts, 24,753 megawatts of solar, 4,405 megawatts of storage, 312 megawatts of gas. Other remains the same. The overall pending GI request originally stated 70,673 megawatts of total. The new number is 84,099 megawatts total.
With those changes to Exhibit 200, are Exhibits 200 and 201 your testimony here today?
Yes, they are.
I offer Exhibits 200 and 201.
Okay, before you do that, let me ask Dr. Mark, would you please repeat the first two of your updated numbers for wind and solar?
For wind, it's 54,625 megawatts. For solar, it's 24,753.
And then you gave a total. Is that total listed in here anywhere?
The total is listed in the testimony, it's listed at the top left-hand corner. It says pending GI request.
Oh, I'm sorry.
And that new number is 84,099 megawatts.
Okay. With those updates, would there be any objection to Exhibit 200, which is in highly confidential and public version, the rebuttal testimony of Jeff Mark, and Exhibit 201, highly confidential and public, the surrebuttal testimony of Jeff Mark? No objections, then I will admit those exhibits.
I tender Dr. Mark for cross-examination and questioning by commissioners.
Is there any cross-examination by staff?
No questions.
MECG?
No questions.
Division of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
No questions.
Are there commission questions for Dr. Mark? Commissioner Hall?
Good morning.
Good morning.
Do you believe that the levelized cost of energy related to these three wind projects, well, first, do you have an understanding as to what the levelized cost of energy will be for those three wind projects?
I have a general idea. I don't have an exact number.
Do you believe that that number is lower than the anticipated market price for energy in SPP over the next 10 years?
My contention is that it will not be lower. over the next 10 years.
And what is the basis for that understanding?
I'm bullish on renewables. I think there's a lot of wind coming online. The technology, really the list of unknown variables that were put out there by Mr. Williams in his opening statement. I think there's a lot of reason to believe that the SPP market and just really the U.S. as a whole is undergoing a seismic change. My concern with these renewable projects.
Yeah, okay, but I'm talking specifically about the LMP in SPP, the market price going forward. So I think there was testimony yesterday and written testimony provided before that shows estimates for market prices over the next 10 years or so. You disagree with that? You think it's going to be substantially lower?
Yes.
And you think it's going to be and is there any scholarship you could point to that would support that assertion that the estimates provided by the company and supported by staff are inaccurate?
Well, both the estimates that were recorded by or referenced by staff and the company are already several years old as it stands. It really is reflecting a different market. As far as scholarly evidence to suggest that wholesale market prices are depressed as more renewables are penetrating, both myself and Lena Mantle reference an MIT study and a Lawrence Berkeley National Lab study that speak to negative prices and the overall dampening impact of if at a certain level what would happen with renewable penetration. I think this is compounded by the FERC order and pending legislation by U.S. Congress to go ahead and support storage. I think all of those things make the proposition that the
FERC order to support storage is going to result in lower market prices in SPP?
Right.
FERC connect those dots for me, please.
Sure. FERC order 841, storage to promote storage penetration. Essentially, depending on how you deal with storage, you'll have more generation to go ahead and bid into the market than you otherwise would. That storage for wind at 3 a.m. can be stored and be then. So
you're assuming that the incentives that are in 841 are going to result in some substantial technological innovation in the near future that's going to result in storage being put in place in the SPP footprint that's going to dramatically lower the price of energy.
I would take more comfort if it was just one thing that I was resting my hat on. It's many different things that I think that will depress that.
Okay, well, I do agree with you that there is going to be a pretty significant increase in wind penetration in SPP. I don't necessarily agree with you that that's going to result in a substantial decrease in the market price, but let's just put that aside for a second. You make the argument that it would be better for ratepayers if Empire were to run the wind business below the line.
Yes.
And let's say that the company is correct and that staff is correct that the price of energy in SPP is going to be substantially higher than the levelized cost of energy for those 3 wind facilities. Do you still take the position that it would be better for ratepayers for this to be a below-the-line activity?
That's a good question. There are 2 approaches I would say that our office really focused on. One was just that market approach, and from my vantage point, even if we assume that this did make sense, Well, that would be the regulatory approach. Should you depart from that?
Let me do this.
Okay.
I understand your philosophical argument that if Empire ratepayers are not in need of this additional energy, then if Empire is going to provide it, they should do it as a below-the-line activity. I understand. I don't necessarily agree with it, but I understand it.
Mm-hmm.
But just from a dollars and cents perspective, would it not be better for Empire's ratepayers for this to be a regulated activity if there is that difference between the levelized cost of energy and the market prices?
That presupposes that you couldn't take an action here in 2 years, in 3 years, and again in 4 years. This window that we're talking about here just doesn't go away. Empire can go ahead and make investments again next year. They can go ahead. There's other opportunities. From our point of view, we've sunk in a substantial amount of money the last couple of years to be put for Empire ratepayers.
You're trying to answer a much bigger question than the kind of simple Econ 101 or 201 question that I'm asking. And that is, if there is a gap between the levelized cost of energy and the market prices, would it not be better for Empire's ratepayers for this to be a regulated activity?
Assuming that they don't need it.
Whether they need it or not. I mean, everything gets sold into SPP and everything gets purchased back. So in terms of the economics of it, it really doesn't matter if they're long or short.
I mean, to answer that question, it's how much of a risk appetite do you have? How confident are you of 3-year-old models, 10, 15, 20 years in the future?
I would think as an economist, you'd be able to do this. I'm asking you to hold certain things constant. I'm asking you to make certain assumptions. Okay, the assumption, levelized cost of energy here,
right.
Market prices above it.
Right.
Those are assumptions.
Mm-hmm.
If that is in fact true, would it not be better for Empire's ratepayers for it to be a regulated activity?
Commissioner, my pause here is with all the other confounding variables that I'm wrestling with.
But I'm not asking you to wrestle with those. I'm asking you to just focus on the ones I provided, unless there's something that, well, no, I'm just asking you to look at the variables I provided.
So, to restate, is it better to be regulated or non-regulated if I can sell this wind at a premium price well into the future, even though I don't need it?
If you could sell it above what it costs to produce it.
If I could have some guarantee that it would be covered, it would be.
It would be covered, what does that mean?
Like the tax equity partner hedge, really that would be the example. If you're a tax equity partner, what makes this attractive is that even if that doesn't happen, I'm still okay. I'm still getting a return. I'm still being covered at this. My fundamental struggle with this is a very really simple question, and just ask yourself who loses if we're wrong. It's not shareholders. It's not.
Yeah, but I mean that's not really part of my hypothetical, and I understand those concerns, and they are legitimate concerns. But I'm just trying to understand from your perspective as an economist, if the levelized cost of energy is below the market price, then it would be better for Empire ratepayers if this was a regulated activity.
And again, for the life of the project.
Yes.
If those were the only two assumptions you were looking at, then yes.
Okay, thank you.
Are there any other commission questions? All right, I just have a couple for you, Dr. Mark. On page 2 of your rebuttal, you say OPC recommends that the commission impose hold harmless conditions to ratepayers upon the CCN that provide meaningful customer protections. just to clarify with the current stipulation and agreement, non-unanimous stipulation and agreement, does that opinion remain the same as you sit here today?
I would couch that as in part, and if you allow me to explain.
Go ahead.
Our position statement actually deviated from what is in our testimony slightly. I would characterize it as we said to move forward with the projects, and essentially that ratepayers would be willing to go ahead and put in $25 million. I'd characterize it as a GoFundMe, essentially. We as far as a social good here, there's $25 million that ratepayers would be willing to go ahead and put up. But the revenues based off of those models and the assumptions, all of those benefits would, if they're right, would then go to shareholders just like it would in any other merchant generation investment.
Okay. And then my next thing is maybe my own personal pet peeve. At page 18 of your rebuttal, you say at line 5, OPC has taken many issues with Empire's modeling. Rather than rewriting them, I have included my rebuttal, surrebuttal, and affidavit from case number EO-2018-0092, which are found in attached schedules GM3, GM4, and GM5 respectively. Okay. So the parts of that testimony attached to your testimony
Yes.
that you're really adopting here today have to do with the modeling, correct?
That's correct.
The parts of that testimony reviewing Empire's proposal and other things, are those still relevant to this case?
I believe so.
Okay. It's hard for me to parse out from one case to another. I mean, I understand you don't want to reproduce everything, but it makes it difficult for the commission to evaluate the evidence when whole parts of another case are dumped into the record.
Judge, if I may.
Yes.
I hear you, and I will take it under advisement for future writing.
Okay.
But we did struggle with how to include that we objected to the modeling, knowing that the modeling actually wasn't in the record. And I think even sitting here today, I wrestle with that even when staff opens up with slides of the modeling, right? So, to the extent that we're relying on models that are 3 years old to inform the assumptions that are not going to go into effect for another 2 years and then impact the next 30 years, that was the rationale behind it. But the point is absolutely made. It is voluminous. There's a lot of work there.
No, and I appreciate your explanation because that makes a lot of sense, and I appreciate that explanation. So then the only other thing, and this is just really to clarify the record, is in that attached, in your surrebuttal testimony, you have some attached schedules, and I just want, like I say, I'm just clarifying this for the record. Those schedules are also labeled GM1, GM2, and not otherwise marked as your surrebuttal schedules. I just wanted to clarify for the record that those are in fact.
In the surrebuttal, not
Right, okay.
the rebuttal, right?
Okay. That's, like I say, just a clarification. Okay. With that, is there any further cross-examination based upon questions from the bench from staff?
Thank you, Your Honor.
MECG?
No questions.
Division of Energy? Renew Missouri?
Thank you, Judge.
Empire?
No questions, Your Honor.
Is there redirect?
Thank you, briefly. Do you recall Commissioner Hall asking you some questions about, I guess, the contrast between increasing market prices in the SPP and decreasing market prices in the SPP?
Yes.
What about the circumstance where prices don't increase as quickly as Empire has modeled them, or they remain level?
Under such a scenario, and there were many different scenarios modeled, but the benefits decrease, and they can decrease to the point where there's a liability and a cost that's then associated with moving forward with this venture.
And then Commissioner Hall struggled with you on the benefits, I guess, to customers if you were given certain assumptions about the levelized cost of energy being below SPP market prices. You call that?
I do.
Was the assumptions that you were given in that hypothetical appropriate for this case?
No.
Why not?
This is a complex case. It's obviously taken several years to go ahead and to map through. There's still a lot of uncertainty surrounding it. There are a lot of interdependent variables that can influence price. The production of these wind farms and essentially whether or not they'll be in the money in the future. The big concern, and there's many, is that we effectively stopped looking at those concerns or those models. We said we got some sort of clearance over a year ago, and then everything is fine. I can't think of any sort of situation where $1 billion+ investment, that you would put up $1 billion+ investment on something and not have more accurate data. I struggle with it, other than in a situation like this, if I'm an Empire investor, where I know I can get the backing of captive ratepayers.
No further questions. Thank you.
Okay, thank you. I believe that concludes your testimony, Dr. Martin.
Thank you.
Would OPC like to go ahead and call its next witness?
Going to have a changing of the attorneys.
Your Honor, OPC calls John Robinette.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. Your first question is, how did the exam go?
Hopefully, well, I'll find out in about, best case scenario, 4 weeks, more likely 6 to 8.
Okay, you can go ahead, Mr. Hall.
Thank you. Good morning. Please state your name for the record and spell it for the court reporter.
John A. Robinette, and Robinette is Robinett.
By whom are you employed and in what capacity?
The Missouri Office of the Public Counsel as a utility engineering specialist.
And on whose behalf are you speaking today?
As an employee of the OPC.
And are you the same John Robinette who caused to be filed rebuttal and surrebuttal testimony in this docket?
I am.
And that testimony includes both highly confidential and public versions?
Yes.
If I asked you the same questions within your rebuttal testimony, would your answers be the same or substantially similar as the answers you gave in your rebuttal testimony?
They would.
If I gave you the same questions that are asked in your surrebuttal testimony, would your answers be the same or substantially similar as what you gave in that surrebuttal testimony?
They would.
Do you have any other changes or corrections to make to either your rebuttal or surrebuttal testimony?
I do not.
Is it your understanding that these testimonies have been marked as Exhibits 202 and 203 for rebuttal and surrebuttal, respectively?
Yes.
Your Honor, at this time, I offer Exhibits 202 and 203 into evidence.
Would there be any objection to Exhibit 202, the rebuttal testimony of John Robinette, and Exhibit 203, the surrebuttal testimony of John Robinette, in both the highly confidential and public versions?
Staff has no objection to the testimony, but, and maybe I missed it, did the witness get sworn in?
Yes. Any objection to the testimony? Seeing none, then I will admit those exhibits.
Your Honor, I tender the witness for cross.
Is there any cross-examination by staff?
No questions.
MECG?
No questions.
Division of Energy? Renew Missouri?
Thank you, Judge.
Empire?
No question.
Are there any commission questions? Mr. Chairman? Oh? Mr. Kinney? Commissioner Kinney?
Were you sworn in, stand, raise your hand?
Yes.
Yes. I'm just that good. Any further cross-examination? Any further cross-examination based on Commissioner Kinney's question? Okay. Back to serious business here. I see that there are no questions for you, Mr. Robinette, so you may be excused.
Thank you, Judge.
At this time, Public Counsel calls OPC witness John Riley.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you.
Please state your name for the record and spell it for the court reporter.
John Riley, R-I-L-E-Y.
By whom are you employed and in what capacity?
I work for the Missouri Office of Public Counsel as a utility accountant 3.
And in whose capacity are you testifying for today?
Testifying for the Public Counsel.
Are you the same John Riley who caused to be filed in this docket the rebuttal testimony on February 5th of 2019?
Yes, sir.
Are you the same John Riley who also caused to further be filed corrected pages to that testimony filed at some later time?
That's correct.
If I asked you the same questions that are included in that rebuttal testimony, would your answers be the same or substantially similar as what is given in that testimony?
Substantially similar, but I do have some corrections.
Could you please walk us through those corrections?
Yes, sir. I had one change, however, Eagle Eye Mr. Holmes pointed out I had a typo, so that unfortunately caused several things to be changed. Starting on page 5, on line 16, the number 113 would be 112.
Okay, let's back up. So that's of the corrected testimony, and are those numbers still confidential?
They're just data points, and I'm under the assumption that they are not.
Okay.
Pardon me, Your Honor. I should have actually asked before you've gone through that. Based on discussions we had with the company yesterday, we believe that we were treating this information as confidential based on our understanding of Empire's view as to that data. We believe now it is now confidential. Maybe before we go through any of the changes, it would be better for me to move at this time that the highly confidential nature of John Riley's testimony be removed and that we treat his entire testimony as public at this time, barring any objections from Empire.
And would the company have any objection?
None, Your Honor.
Okay, then we can remove the highly confidential confidential, I can't speak today, designation of Mr. Riley's rebuttal testimony and the corrected pages. Okay, now return to your corrections.
Okay. The page 5 was 113, was changed to 112. The page 8, line 25, the 41 should be changed to 81. Page 9, excuse me, line 24. The 14 should be changed to 9.
I'm sorry, I got lost there. Did you say page 8?
Okay, we were at page 8, line 25, last line. There was a 41.
okay.
We changed that to 81. And on page 9, line 24, there was a number 14 was changed to 9.
And that's of the corrected page 9.
That's correct, page 9, yes, ma'am.
14 changes to, sorry.
9. Now, the typo error in corrected schedule JSR-R-2. And I apologize that when I first said page numbers, when I went to PDF, the page numbers, or the line numbers disappeared. But on column 25 of that schedule, about halfway down, there is a .69. As Mr. Holmes pointed out, that was a typo. It should have been a negative .69.
So when you say column 25, you mean 2025?
2025, year 2025.
And which number?
.69 should have been a negative .69.
Mr. Riley, you're referring to the row that's labeled Empire's PTCs, correct?
That's correct. Which, of course, a change in that number will cause a change in revenue requirement line below. Change from a 79.00 to 77.62. And below that on net revenue requirement was a change from 9.25 to 7.87. And continuing on net revenue requirement over to the far right, it would change the cumulative total of 112.89 to 111.50. That's all the changes for JSR R2. However, the same changes need to be made on JSR-R-4. On column 2025, Empire's PTCs, instead of being a .69, should be a negative .69, which will change the revenue requirement below that from 69.74 to 68.35. And below that, on the net revenue requirement line, that there is a negative .01, it would increase to a negative 1.40, and that would change the total line to the right from 10.12 to 9.49. That's all my changes.
Very well, thank you.
Mr. Riley, is it your understanding that all of these changes up through today were incorporated into a substitute exhibit labeled 204?
That's my understanding.
Now, does the substitute exhibit 204 represent a true and accurate representation of your testimony today?
Yes, it does.
Your Honor, at this time, I move that substitute exhibit 204 be admitted into evidence.
And you are including the corrected pages with the original filing
That is correct. The substitute version has been given to the court reporter. It has a title at the top to signify that it was corrected on this date to demonstrate that, or to make it clear that this is the latest version.
Okay. With those corrections, would there be any objection to corrected rebuttal testimony of John S. Riley? Seeing none, then I will admit that into evidence.
And Your Honor, at this time, I tender the witness for cross.
Would there be any cross-examination from staff?
No, thank you.
MECG?
No questions.
Division of Energy? Renew Missouri?
Thank you, Judge.
Empire?
Just a few questions. Mr. Riley, are you aware that Mr. Holmes's opinion is that you've used the wrong source of expected revenues in JSR-R-2, the corrected version?
Yes, ma'am.
Would you agree with me that if the numbers in that expected revenue line were incorrect, that it would impact the math that flows through your JSR-R-2?
If they were incorrect, yes, ma'am.
Company has no further questions.
Are there questions by the commission, Mr. Chairman? Commissioner Kenny, Commissioner Hall?
Morning.
Morning.
Have you reviewed the testimony submitted by Mr. Holmes in this case?
Yes, sir.
And in particular, the schedule attached to his SIR rebuttal that sets forth a revenue requirement related to the wind facilities at issue in this case?
Yes, sir. DH-S-1.
Okay, without going, I hope we don't have to go line for line through here, but could you tell me, well, what does the net benefit from wind at the bottom, and I'll look to the company, what this is designated as highly confidential, the numbers, any numbers on here? Okay.
If you could, I apologize, Commissioner, restate which schedule page you're looking at.
Actually, he stated, because I have a whole bunch through.
DH-S-1.
My understanding is that the shaded confidential information on DH-S-1 relates to pricing information that the company has received, whether it's from third parties, potentially with regard to these various categories of costs.
So none of the other numbers are confidential in nature?
In addition, the dollar per megawatt hour line, it says from ABB Wind Study, 600 megawatts. And the reason for that is that it's based on information, the ABB market price information upon which the company relied, and non-disclosure requirements that ABB has insisted that the company follow with regard to use of those market price forecasts that were purchased.
Okay, so the bottom line calculations on net benefit from wind, nothing confidential there?
Correct.
Okay. So according to this calculation, what the net benefit from these projects is what?
I believe the net benefit is the revenue shortfall, or as you go along, the greater revenue, the net income of the project as you look at revenue requirement and expected revenues.
Well, it goes positive in 2024 and it goes up to 19.5 in 2031, according to this, right?
That's what I see, yes, sir.
Okay. So what inputs or what calculations do you disagree with on this schedule?
Well, when I took their work papers and like I said in testimony, I did not calculate the revenue requirement. I did not calculate their net revenues. I took it off of spreadsheets that were provided to OPC and plugged those in. And what was in the revenue was a percentage of hedging and the expected market price for each. I used an annualized one, but I double-checked it against the monthly ones and added all those up and came up with a revenue. Now, what I found was...
So you disagree with the anticipated market price that is part of this calculation?
Yes, sir.
Okay, so that's one. What else?
Okay, well, what's not on here, and what I was trying to get to, is that I found that the revenues did not include what is referred to as the pay-go, whether the tax equity partner pays or gets paid from the Winco company, and it also did not back out the hedging costs that are built into the revenues.
But if the actual market price is as Empire believes it to be, those other two scenarios don't matter, correct?
Yeah, I see where you're going with this. If they're essentially, if their numbers are correct, we all go home.
Well, their numbers meaning the market price.
Money. Right.
Okay.
The hedge would not be.
So if the anticipated market price is as is assumed in this schedule, then you do not take issue with the calculation at the bottom of the page.
Well, the calculations, yes, I do. Hedging is not included in there.
But if the market price is as is anticipated, there won't be any cost from hedging.
But as we see, there are some negative numbers, and then they turn positive. So,
and don't those net out then?
If I know that some of the hedging prices are. Well, hedging price is higher in the first two model years. So after that, it would hedging would not be a factor in the calculations. You're correct.
Okay, thank you.
Are there any other commission questions? right. Is there any cross-examination based on questions from the bench, from staff?
No, thank you.
MECG? Division of Energy? Renew Missouri? Empire?
There are none.
Is there a redirect?
Thank you, Your Honor. Mr. Riley, there's been some criticism as to what revenues you used in your analysis. Where did you get the expected revenues for your calculations?
After the company filed, they had forwarded spreadsheets on each project, on each separate project, and then a levelized cost of energy spreadsheet. And I went to those for each project and took if you printed the spreadsheets out, it'd be 275 pages, so I wasn't going to bring it here. But the spreadsheets are broken into revenues, broken into expenses, broken into various subsections of their study on this project. And what I did is I went to the revenue section and took the numbers that were generated there and put them into my spreadsheet. So for Neosho Ridge, I pulled in the annual expected revenues that were listed on there, and for the other two in Missouri, I pulled those all down, I combined them all together, and that is how I came up with the expected revenue numbers that I have on my JSR R-2. So if I'm using the wrong numbers, then those numbers were provided by, the numbers I used were provided by the company. So Mr. Holmes says that he was using ABB projections. If mine aren't ABB projections, then I can't tell you why I got those spreadsheets from them and why they aren't correct.
Mr. Riley, to be clear, you were using numbers that you said after the company filed. You're referring to this docket, the 2019 case?
This docket, yes, sir.
And Holmes's schedules that he offered in rebuttal of your testimony, is that relying on the data from the 2018 case?
I'm not really sure. I'm not. I know it's very similar. I'm not sure the numbers are all the same.
As to the 2018 or the 2019 case?
2018. I'm not sure if the 2018 numbers. This spreadsheet's very similar to the 2018. I can't tell you that the numbers are the same.
They're similar to the 2018 case, but the company did not present an analysis of the expected revenues in its direct testimony, did it?
I'm not real sure.
Did Holmes represent these expected revenues in direct testimony at the filing of the 2019 case?
Mr. Holmes only filed server rebuttal.
So he only waited to file this after you had spoken? After you had spoken?
Yes.
At a time when no other witness could provide testimony to rebut him?
Yes, you're right, yes.
A question from Commissioner Hall brought you to a discussion on the hedge. Does Mr. Holmes's expected revenue projections include the hedge?
I don't think they do, no.
If that is the case, what would happen in a scenario where there's a revenue shortfall?
Well, there'd been a lot of talk about the hedging and how it's not supposed to impact the ratepayer. And if I can give you a simple scenario to show you how hedging is going to affect the revenue requirement, it might be a little clearer. If we look at this, and one of the reasons why I filed this testimony and put in these exhibits as a revenue requirement is because when this is all said and done, this is what we got to look at. The next rate case, we're going to do a revenue requirement. So what I did is I filed this, and I looked over all their numbers on their spreadsheets and saw that the revenue requirement included hedging. So I had to back that hedge out because that is a true cost to the ratepayer, no matter what these two witnesses will tell you. What happens is, let's look at it this way. revenue requirement, after it's all said and done, the commission has decided what's going to be in cost and what's not. Let's just pick a number, $100 million revenue requirement. That requires $100 million in revenues to cover revenue requirement. So what happens in this scenario, what's going to happen is we have this wind company selling wind into the market. So let's just say that the wind's going in as it expects, but the price is low. We don't want to muddy the waters with anything. Let's just say that the price isn't what it's supposed to be. So the hedge is going to kick in. Okay, so we need $100 million. Let's say the Winco company sells everything into SPP and they get $80 million. So we're short $20 million. Who's got to pay that? Well, according to what I understand, is Empire is going to pony up $20 million and give it to the wind company. Well, the wind company is going to give all that money back. So they're going to give you back $100 million. And what we're hearing from company is that's a wash. That is not a wash. What happens is, in revenue requirement, is that the $20 million will be booked as a purchase power cost, and the $80 million or $100 million, you can take your pick, is going to be charged as off-system sales. But when you do the math, you're short 20 million because when it comes down, you've got 20 million over here, you've got 100 million over here, and it nets out to 80. However, we got a revenue requirement of $100 million. So we've got a $20 million shortfall. So that is going to go into revenue requirement, and the ratepayer is going to be the one that has to do the backstop on that.
Thank you. No further questions.
Sorry, I believe that concludes your testimony, Mr. Riley, and you may step down. I know it's a little early still, but I think that we're going to take a break for lunch before we go to OPC's last witness. And because we're running a little earlier than I had anticipated, we'll reevaluate the remaining witnesses while we're on break. And so with that, we can go ahead and take an early lunch break, return at 12:40. We can go off the record. Okay, let's go ahead and go back on the record. All right, we are back from our lunch break, and Ms. Mantle has already come to the front. I believe she is the next and last witness for public counsel. If you please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead.
Would you please state and spell your name?
My name is Lena M. Mantle. My last name is Mantle.
And by whom are you employed?
I'm employed by the Office of the Public Counsel
In what capacity?
as senior analyst.
And for whom are you testifying here today?
I'm testifying on behalf of the Office of Public Counsel.
And did you prepare rebuttal testimony and surrebuttal testimony, both of which contain highly confidential information that have been marked for purposes of identification as exhibit numbers 205 and 206 in this case?
Yes, I did.
And for that to be your testimony here today, would you have any changes to either of those exhibits or both?
I have one change in my rebuttal testimony.
And where is that change and what is it?
On page 10, line 8, my testimony said the SPP market has only been operating since March of 2015. That is actually March of 2014.
So your correction is to change March of 2015 to March of 2014?
Yes.
Do you have any other changes to either of the exhibits?
No.
And with that change, are exhibit numbers 205 and 206 your testimony here today?
Yes.
I offer exhibits 205 and 206. And there are both highly confidential and public versions of each.
And let me just clarify. So, Ms. Mantle, your rebuttal testimony, the version I have anyway, says confidential. Is it? We had a special protective order in this case. So, is it confidential or highly confidential?
Well, the outside says highly confidential, but inside on different pages it says highly confidential.
Okay.
As a layperson, I'm not for sure.
Okay. So are there any objections then to exhibits 205 and 206, which I am marking both as highly confidential? And I'll have to double check to see how they were originally filed in EFS. But would there be any objection to 205 and 206 in all of its versions coming into the record? Seeing none, I will admit those exhibits.
I tender Ms. Mantle for cross-examination by the parties and questioning by the commissioners.
Is there any cross-examination from staff?
Questions?
MECG?
No questions.
Department of Energy?
No, Judge.
Renew Missouri?
No, thank you, Judge.
Empire?
Yes, Your Honor, I have one question for Ms. Mantle. Ms. Mantle, in this case, are your concerns about Empire's use of market price forecasts based on the source of those forecasts being from ABB?
No.
Thank you. The company has no further questions.
Are there questions from the commissioners? Commissioner Hall?
I want to follow up on that question. So your concern about the market price forecasts is not a function of the source?
That is correct.
Which means what about your view of the source?
The market prices forecast. I don't believe that I could believe anybody's market price forecast with enough certainty to bet $1.1 billion. ABB used software that they've used for years. They used an analysis type that's been used for years. But we're entering into a whole new era where we have so much wind. It's different than coal plant. It's different than a combined cycle or CT. How it affects the market is completely different. So when you have as much wind as we have going into SPP, to rely on a forecast methodology based off history of a completely different resource provides, while it may be the best forecast out there, it's completely into the unknown.
So would you agree it's the best forecast out there?
I don't know if it's the best. I don't know of a better way other than short of what I read through that MIT has provided in the paper I attached to my testimony. And then Lawrence Berkeley Lab also had some suggestions.
So you've got some criticisms of the forecast, but you don't have a better forecast, or you're not aware of a better forecast.
If this was a project to meet customers' needs, we were building and we had to have something out there to model against. I was around when the original resource planning rule was developed, and I was on staff when it was redone. The whole idea is to look at different possible futures out there in resource planning, because the customers will need some technology to provide their electricity usage. So you go with the best that's out there. And now, and with what Empire is proposing, this isn't to meet customers' needs. This isn't, we believe in the first 3 years, we're pretty sure we're going to be below market price. Market's going to be higher than our price. There is no certainty about this other than it's going to cost the ratepayers the way Empire's proposed it. So it's a different type of analysis, and you put a different weight on that market forecast.
So on page 4 of your rebuttal testimony at lines 7 and 8, you say, consistent with what you just testified to a moment ago, that the benefits to the customers from granting this certificate are entirely reliant on SPP market prices, and you could parenthetically say high SPP market prices. Is that correct?
They are contingent upon market prices that are constantly increasing. There was no analysis of what happens if market prices stay flat. There was no, so it's higher than they are now, and it is going up.
So you're not considering any potential benefit from a no carbon source of generation, if it were to replace fossil fuel generation? That's not a benefit that you're taking into account. Pretty simple question.
I know. What I'm thinking of, it's economic, but it's not just economic, because it's economics for the customer that's going to have to decide whether to pay for their prescriptions or pay their increase so that Empire can do this. So I'm looking at some that aren't necessarily.
But you're not
economics.
taking any benefit to the environment into account. You didn't consider that.
I don't know that this is going to displace any of the other.
But it might.
Coal. Yes, it could.
Okay, so if it were to replace some coal production, either at a facility owned by Empire or by another facility within the SPP footprint, there would be some environmental benefit, and you're not taking that into account.
No.
And you're also not taking into account the possibility that the additional 600 megawatts from these three facilities might actually might put some downward pressure on market prices, which would inure to the benefit of ratepayers. You're not taking that into account, are you?
If it drives down the market price, this 600 megawatts is not going to be the driver. There's so much. If market prices go down because of wind, it's not because of this 600 wind. It's because of the additional 30 to 40 gigawatts of wind that's out there. And that would be seen by the customers regardless of whether Empire builds these three wind farms or not. So those benefits will be seen by the customers.
And that's fair enough that this 600 isn't going to be a driver in a reduction of prices. But if prices do go down, that does benefit ratepayers, correct? In terms of the price they pay.
If they don't build these, if they aren't being charged for these wind farms.
Separate and apart from that, I'm not looking at the cost. I'm just looking at a possible benefit. Let's move on. Do you believe that there is some benefit to ratepayers with a diversity of fuel source?
Yes, but this is not making Empire more diverse.
If it were to replace a coal facility, would it make Empire more diverse?
No.
Okay, I need some help with that one.
Empire, this addition of the 600 megawatts of wind will make Empire heavily reliant upon wind. Diverse means some coal, some CTs, some combined cycles, some wind, some solar. And no one of those technologies being a whole lot more than the others. If you want diversity, you want different types that respond to different fuel costs, to different market prices.
Well, I guess I'm not sure I understand. Right now, there's about 255 megawatts of wind that they have purchase power contracts on. Is that correct?
Yes.
And so this would replace that and possibly some coal, correct?
In the future, it would be there when the PPAs that they have end. I don't know.
Okay.
Replace is, but I don't know whether, it's only 90 megawatts of accredited capacity for SPP is about what it would be, which would not replace a coal plant. It doesn't replace the reliability you get with a coal plant. It doesn't replace the certainty of it being there that a coal plant has.
It seems like you're kind of talking out of both sides of your mouth here, though, because you're saying that the addition of these three facilities is going to make Empire overly wind reliant. And therefore, there will not be diversity. But then you're also saying that it's not going to if you compare it to the wind it already has, it's not going to bring that much more wind into the mix. So which is it?
It would be in addition to the current PPAs that they have, and those will end in 2025 and 2028. So one way to look at it is replacement. That is a way to look at it, but that's not till 25 and 2028.
Okay. Are you familiar with paragraph 17 of the non-unanimous STIP regarding Asbury? Did you review that provision?
I have read it, yes.
Would you agree that the intent of that provision is to protect ratepayers from the possibility that Asbury gets retired or sold sometime between now and the next rate case, and ratepayers continue to have to pay the depreciation, the return on on equity and all the operating related to that facility, even though it's not running. Would you agree that the intent of this provision is to protect ratepayers from that contingency?
I would say that it's to have the information necessary to make a determination on in the future to hopefully protect the customers, yes.
Okay. Is there language in there that you believe could or should be tightened up to better protect ratepayers, or do you believe that it's drafted sufficiently for that purpose?
I'm not an auditor, so I can't say.
Yeah, but you've been around here a while. You've seen these provisions.
A few, but
and if I guess in the briefing, the post-hearing briefing, if public counsel believes that language should be modified to further protect, and MECG for that matter.
You said I've been around for a while, and what I have learned is you think you've got everything in, and then 3 years down the road you find out you missed something. So,
but sitting here today, there's not any portion of that section that you think could be tightened up or improved?
Not that I can tell.
All right, thank you.
There be any further cross-examination based on the commissioner's questions from staff?
No, thank you.
MECG?
No questions.
Division of Energy?
No, Your Honor.
Renew Missouri?
No, thank you, Judge.
Empire?
None, Your Honor.
Is there redirect?
Yes, thank you. Hopefully briefly. You talked about, in response to a question by Commissioner Hall, that wind are different than coal and CTs with regard to history, and then using that history for doing forecasts. Would you explain how wind and coal are how wind is different than coal and CTs?
Wind has no emissions. I will grant that, but you don't know when the wind's going to be blowing. It's an intermittent resource. Coal is typically a base type of plant. Can follow load. And again, CTs can be brought up very quickly, and they are reliable. You know, when you turn them, you can turn them on and it will be there. You don't get that with wind. And the other thing with wind, because of the production tax credits, it's often run when it is not necessarily let to generate energy, when it's not necessarily a good idea with the market price. So we have the negative market prices that are happening in the SPP market, and the purchase power agreements that our utilities currently have for wind, those utilities have to generate with that wind regardless of the market price, because if not, they end up paying for the production tax credit and the negative price. And the cost of the megawatt hour anyway. But of course, that's a product of a PPA versus ownership. In this case, because there's a tax equity partner, it would be run because the tax equity partner wants that revenue to offset its investment. There are tax incentives with coal. I'm not as familiar in CTs, but I'm not aware of any that requires a plant to run when it's not economic to run.
You seem to have indicated there's an importance between the availability of a generating resource and, I think you used the word load. Is that the same thing as demand for energy?
Yes. Your CTs, your coals, your combined cycles can follow load. In other words, they match the load that's out there. With wind, it could, if it wasn't trying to get the production tax credit, curtail if the wind was blowing, but you could not say, I need a megawatt hour. If the wind's not there, it doesn't make any difference what your demand is. You're not going to get anything out of that wind generation.
And you talked some about using historical information for making forecasts. Are you aware of any examples where that's been done?
There was, I'm aware of a lot of examples, and in particular, most of the wind PPAs that are out there for our utilities have been entered into some basis of economics off of forecasted market prices. And I'm not aware of any PPA for any utility right now that where it is earning more revenue from the RTO, whether that's MISO or SPP, than what the utility is paying for that PPA in a given hour. And in particular for Empire, the two PPAs that they do have, and they entered into in 2005 and 2007, and I was on the commission staff then, I remember back, and I've gone back and looked at the forecast used to enter into those contracts. And at the time they were entered into, the prices were not superb, but because of the high natural gas prices, these look like a pretty good deal. But in the past 2 or 3 weeks, I've been looking at the FAC reports that are provided by Empire every month, and I have found that these PPAs have cost the customer between $12 million a year and $18 million a year. And that's because the forecasts that were used when these were entered into said that market prices were going to go up. And what I've seen is the market prices actually went down. And for that reason, Empire's customers, even though this is wind and the fuel cost is zero, the PPA cost isn't. And the revenues that they're receiving from SPP are sometimes half as what they're paying through the PPAs.
And directionally, how are ABB's forecasts that Empire is relying on in this case in terms of how they change over time? Are they increasing, decreasing, level, variable?
They are going up, and the forecast that was used to enter into the PPA is ABB used the same models that it was Ventrex, I think back in 2005, 2007, but they used the exact same models, the exact same type of analysis to do those forecasts back in 2005 and 2007 to enter into those contracts. And that's the same modeling that I see done now. And those prices, just as they did then, show, even though they have a low, medium, and high case, the low market prices still are just incrementally climbing every year. And I've yet to see a market where they go up. Usually they're all over the place. But the forecast used, both the low, medium, and high, for the modeling that was done in the 2018 case, because there was no modeling done in this case, was to continually increase across time.
Now, would you explain what point you were making when you were responding to Commissioner Hall about the impact of these projects, or what impact these projects would have on the SPP market prices?
There's 2 studies that are attached to my rebuttal testimony from very reputable research centers, one from MIT and one from Lawrence Berkeley National Lab, that show that their analysis shows that the more wind that comes on, there's a dampening to the market price. If in SPP, the 600 megawatts was all that was coming on, it would barely hit the market price. But because of all the market or the wind that is being proposed to be added to SPP, it's in Dr. Mark's testimony and mine, I expect a real dampening of the market prices, which right now aren't even at where Empire said they would be for 2018.
Well, it's another way of characterizing that 600 megawatts is a drop in the bucket of anticipated additional wind.
Yes, because we're talking about gigawatts being added to SPP. 1 gigawatt is 1,000 megawatts. This is 600 megawatts, so we're talking a lot more than just what Empire is looking at adding.
Then there were some questions and answers regarding diversity of Empire's supply side resources with and without the addition of these 600 megawatts of wind. What is Empire's current diversity in resources?
Empire currently has, trying to think how many coal plants. They've got part of Plum Point, they've got Asbury up, they've got part of Iatan 1 and 2. And they've got some CTs, combustion turbines, and they've got a couple of combined cycle generation plants that are doing well in the SPP market. And then they do have their 2 wind PPAs, which are generating more than what's required for the Missouri RES and will be until they end. So they've got a balanced portfolio now. They're not heavily dependent on any one generation type or resource.
Can you break, I guess, the generating resources down into megawatts of what you would characterize as baseload, intermediate, peaking, and let's make another category, wind?
Are you asking for the numbers off the top of my head, or
even the relative amounts? I mean, currently Empire has 2 wind PPAs that total 255 megawatts, correct?
Yes, but the accredited SPP capacity, of course, is much less than that. But yes, that's...
Well, if we do it on a nominal...
approximate nameplate.
Yeah, approximate nameplate basis, can you give an indication of the relative resource mix?
I'm thinking about 250 megawatts of coal. Maybe about 300 of the combined cycle, which is an intermediate plant, and a lot of CTs that aren't run very much but are there when they're needed, and then the wind.
Well, Empire's total nominal megawatt capacity between its PPAs and all of its supply side resources is something around 1,700, 1,750 megawatts, correct?
Correct.
And of that, 255 megawatts would be wind?
Yes.
So if you add the 600 megawatts of wind, what's that going to do to the mix?
It's going to make them heavily weighted towards wind.
And are you familiar with when it's considered to start causing issues in terms of wind penetration in the markets?
No.
What's the relationship between SPP market prices and these projects being net beneficial to ratepayers?
For the projects to be beneficial to ratepayers, the market price at the generation nodes for these plants will have to be greater than that LCO, what it's commonly called, we've been referring to as LCOE. There's been some talk about there's zero fuel costs, so even $1 is good, but to be beneficial to the customers, you have to take into account not just the fact that the fuel cost is zero, but that there's capital costs that those customers will be paying for, much like they're paying for the O&M costs for Asbury or any other plant. So really it needs to be above the LCOE for it to be beneficial at all for the customers.
And you said what they're calling the LCOE. What is your understanding of what LCOE is?
LCOE is a way to measure, and it was, my understanding was initially developed so that you could compare different types of generation, coal to CTs to combined cycles. It has been used also for wind, but the one thing that's different about wind or solar or any type of renewable type resource like that is the intermittency. Coal, CTs, combined cycles are there unless they're on a forced outage or a planned outage. There's the variability of wind is not counted in on their LCOE price, but it's supposed to be a way to measure both capital cost, O&M cost, and fuel cost. And in the case of Empire, in this case, they also include some revenue in that determination, what they expect the revenues to be to get the LCOE. In other words, if the revenues are not as high as what Empire's projecting, those LCOEs the actual LCOEs will be higher than what we see because there's so many interdependencies between cost and revenues in the calculation of the LCOE.
And turning back to doing market forecasts, do you have some experience in seeing how market forecasts has changed over time?
Looking at market forecasts for both Empire and recently I've been looking at KCPL and GMOS also, it seems to me what happens is they take the same market forecast that was wrong 3 years earlier and just move it over 3 years. So it's more or less the same market forecast, and it's always going up, the high, medium, low. It never stays flat, it never drops, always going up. But we just take that forecast and we plop it over 3 years, and it's basically the same forecast.
When you say it's the same forecast, you're saying essentially the origin point would be the same, then you're shifting it on the timeline to the right?
Yes.
So if you were going to rely on that kind of a market forecast, you'd want to use the most currently available?
I'd want to go back and look and see what was wrong with that forecast 3 years ago. And are we solving that problem that happened 3 years ago? To me, there's a disconnect between, obviously, a forecast is good, but you got to look at it and see if it makes any sense.
Well, let's assume that there's nothing wrong with how you're doing your forecasting. Would you want to use the most currently available data for doing your forecast?
Definitely, especially when you got a changing market like we have with the SPP, where things are evolving day to day.
I have no further questions. Thank you.
Thank you. I think that concludes your testimony. You may step down, Ms. Mantle. And I had earlier asked Mr. Wilson to stick around in case there were additional commission questions, but I don't believe there are any. So, and I'm looking at Commissioner Hall just in case. I'll let you look at that while we'll discuss. That was the end of the witnesses, right? I haven't missed anybody besides Mr. Hyman, and that nobody had any other witnesses. Okay. So when we were off the record, I had a discussion with Division of Energy's attorney and staff's attorney about cross-examination of Mr. Hyman. None of the commissioners have questions for him, and since we are finished, I hate to reconvene in the morning to see if he's going to be able to even testify. So one option that we might consider is letting staff ask their questions in a written format and letting Mr. Hyman answer that in a written format. And correct me if I'm wrong, but I believe their questions had to do with the Asbury part of the stipulation and agreement. Is that correct? Would council have any objection to that procedure?
You could ask several people to explain that to you, and the one witness that could explain it to you would be Marty.
If that's the scope of the questions, I think we're okay with that.
Would Empire have any objection to that approach?
Not generally.
I would allow objections or rebuttal or cross, I guess, over that.
Recross questions. I mean, I think it's a it's kind of a limited chance that would result or be necessary, but I think I would like the opportunity to review the question and answer at some point.
And I have the same concerns, but from what I'm hearing about the scope, I don't anticipate it.
Yeah, and that's exactly what I'm saying as well. I wouldn't anticipate a problem, but I think I would just want an opportunity to confirm that when I see the question and answer. So.
Well, I think we can do that. What I will ask staff to do is to formulate their questions in writing and go ahead and file those in EFS at the same time that you serve them to Mr. Hyman, and that will let everyone see them. If for some reason you have objections to the questions themselves, I would ask you to make that objection. And then I'll have Mr. Hyman respond by a sworn affidavit to his answers to those questions. And then again, I will let you all have an opportunity to respond to his answers.
So you're anticipating getting the answers even if there's an objection, and then either dealing with it by striking it or overruling the objection?
Well, I'm anticipating if there's an objection that if I will rule on that
For Mr. Hyman?
before the answers. Yes, yes. If there's an objection to the question, I will rule on that objection before answers.
Thank you.
So, okay. Okay, Commissioner Hall does have a couple of questions for Mr. Wilson. Is he still in the room? Oh,
He is, yes, Your Honor.
can I ask you to come back to the witness stand, Mr. Wilson? Okay, Mr. Wilson, I swore you in yesterday and, or earlier today. It hasn't even been that long a day, but you are still under oath.
Okay, thank you.
Thank you.
This should be very brief. Do you have your corrected direct testimony from December of 2018?
I believe that I do. Yes.
On page 2, lines 12 through 14, you indicate that these wind projects will reduce the risk of transmission upgrades and congestion pricing in the Southwest Power Integrated Marketplace. Is that correct?
Yes, with respect to how we evaluated the RFP results.
Okay, well, I was going to ask you to elaborate on that statement.
Yeah, so generally speaking, due to the fact of the nature that they are in or near our service territory, that reduces the risk and likelihood of additional transmission interconnection costs as they go further away from our load.
So is that related to this particular project or existing risk of transmission upgrades and congestion pricing?
With respect to these projects.
Oh, okay. All right. Thank you.
Would there be any additional cross-examination based on the commissioner's questions from Renew Missouri? Division of Energy? MECG?
No, Your Honor.
Staff? Public counsel?
No, thank you.
Any redirect?
No questions.
All right. Thank you very much, Mr. Wilson. You may be excused. Okay, then I believe that concludes all the testimony with the exception of that to come later in written form. If I
may.
Yes.
Would we be able to move at this time to get Mr. Hyman's written testimony submitted?
Yes, yes. Thank you.
We have labeled our exhibit of his testimony that was submitted in this case on February 5th as Exhibit 400.
And let me just ask, as far as you're aware, he didn't have any corrections to his testimony?
I don't think he had any substantive corrections, no.
Okay. And you labeled that Exhibit 400? Was that where we are? Yes. Would there be any objection to Exhibit 400, which is the SIR rebuttal testimony of Mr. Hyman? Seeing no objection, I will admit that.
Judge, if I may, I have one other question about his written testimony. Did you have a time frame within which you would like the parties to conclude that process?
Yes, and I was going to kind of get to that here in a minute. The transcripts are supposed to be available, I think the order said by the 15th, which is Monday. So would it be possible, will staff be able to formulate those questions? How much time do you need to get something filed?
Probably do it tomorrow.
Okay, I will ask staff to file their questions by tomorrow and receive any objections on those questions on Friday. And then maybe, would you think you could have his answers by Monday?
I think so, Your Honor.
Obviously, if for some reason his health precludes him, I would just expect you to make a timely motion to extend the time.
We can do that.
Okay. And then you can make objections to his answers or responses if you think there's further questioning needed or whatever your response might be. It might not be an objection, I guess.
I guess I'm okay with that time frame, but I really don't understand why staff wouldn't be able to have questions before the end of today, given that it was going to pose those questions to Mr. Hyman today, I expect.
That is fine, we can have them today.
Ms. Mers says that they can have them today. So I can bump that time up. I'm just not sure about Mr. Hyman's answers, given that I don't know the nature of his health issues, so.
I understand that, and if the answers are posed, I mean, the questions are posed today, I expect we could provide any objections we have tomorrow.
Okay, I'm seeing agreement to that. So I will ask staff then to file those questions today and have objections tomorrow. I will rule on those objections as quickly as I can. And we'll still look for Mr. Hyman's answers on Monday. Okay. So the procedural order also has your briefs due on the 24th and your reply briefs due on May 6th. Given this testimony issue, do you see any problems with meeting those deadlines?
No, Your Honor.
Okay, I'm seeing no issues there. there was a lot of discussion of the stipulation and agreement, and I think that that should go ahead and be entered as an exhibit. Just to clarify the record.
Judge, you want to do that for both the non-unanimous STIP and the wildlife STIP?
Yeah, let's go ahead.
Okay.
So I will mark those as company exhibits, if that's,
That would be fine. I think we're up to 12.
so let's mark the wildlife stipulation and agreement as 12, and the general stipulation and agreement, non-unanimous stipulation and agreement as 13.
And the well, both of those have a couple of versions, so you need to make note of that, as in confidential versus
Oh, okay,
public.
you're right. Both agreements are also in confident, or highly confidential versions. And I will provide the court reporter copies from EFS of those two documents to be stamped as exhibits and attached to the transcript. Okay, I've also instructed our IT personnel to redact the video from yesterday. It turned out it was just a few seconds of the video. I think it will just be removed. So just to let you know that if you should replay the video, there will be a few seconds which redacts the 2 questions and answers that were meant to be in camera.
But there will be a transcript of that includes those.
Yes, the transcript will have a in-camera transcript that will include those questions and answers. And we've had a lot of issues about the highly confidential versus public nature of information and testimony. I would ask you all to reread the new commission rule on that about explaining whether or not or why something you designate as confidential is confidential, and ask you, in the interest of transparency, to try to keep that limited as you can in the future. And I will attempt to make note of what we have declassified and see that it gets changed if it can in the commission's filing system.
Judge, for public counsel, I'm confident that everything we designated as confidential or highly confidential was because of how Empire had designated it. We'd be happy to change whatever Empire agrees can be disclosed to the public.
I'm sure I'm just discussing the stuff that we have already run across in the course of the testimony. I just want to make sure that in your briefs and in the commission order that you're able to make public as much as you can. If you discover in the course of writing your briefs that there are entire portions of testimony that can be made public that you prior thought maybe should remain confidential, we welcome you to let us know that. And I'm looking at Empire's counsel because I understand that staff and public counsel have a duty to keep confidential what the company has submitted as confidential. So, Okay, is there anything else that I haven't addressed? I'm not seeing anything, so I appreciate your participation and.
Would you give us just a second, Judge?
I'd have one more thing.
We're good for the moment. Thank you, Judge.
Okay, in that case, we are adjourned.
Thank you.
Go off the record.